Good evening and welcome to the 2022 Scott County Attorney Candidates Forum, sponsored by the Shakopee Chamber and Visitors Bureau. Tonight we're gathered at River Valley Church. My name is Michael Clem. I'm an attorney at Helmuth & Johnson and a member of the Chamber. I will serve as moderator. With us this evening are the candidates for Scott County Attorney, Alan Andersen and Ron Hocevar. Candidates are arranged in alphabetical order. The candidates have already recorded video interviews to introduce themselves to the community, and you can see those online, so the candidates will not make opening statements this evening. I encourage you to watch the videos. Tonight, candidates will be asked a series of questions. They will have 60 seconds to respond to each question. They will have 4 opportunities to make rebuttal comments for 30 seconds. The first question will go to Mr. Andersen. Please summarize your career experience before joining the Scott County Attorney's Office.
Thank you. My professional career began about 2 weeks out of high school when I graduated and joined the Marine Corps, where I served on active duty for 4 years. I spent most of my time as a truck driver responding to humanitarian aid crises and hostile North Korean military action. After that, I obtained my bachelor's degree and law degree, as well as my master's degree in public policy and leadership. I worked at the Minneapolis City Attorney's Office as a misdemeanor level prosecutor, and I worked at the Scott County Public Defender's Office as a law clerk, making bail arguments for criminal defendants. And currently now I work at Hennepin County Adult Representation Services, representing people who are facing eviction, indigent people who are facing eviction. And that is my professional experience, not including my time at the County Attorney's Office.
Thank you. And Mr. Hocevar, please summarize your career experience before joining the Scott County Attorney's Office.
Certainly. I'd like to thank the Chamber again for giving me this opportunity to address the public. Thank my wife for, I think this campaign season is tougher on her than it is to me, and also like to thank the representatives from my office who have volunteered their time and support me so greatly. My experience after graduating law school, I went into the U.S. Navy as a Judge Advocate General, where I prosecuted and defended service members for various crimes from theft to missing movement to unauthorized absence to homicide. After leaving the Navy, I came to Scott County Attorney's Office, where I was a line attorney, meaning I prosecuted speeding tickets, misdemeanor, domestic assaults, whatever the case may be, up to first-degree murder. Then I was promoted to criminal division head. Then I was promoted to chief deputy. And when the then county attorney retired, I chose to run for county attorney and fortunately was elected. And now I've been serving as Scott County attorney for the last 8 years, and I'm out of time, and that summarizes my record.
Thank you. And if you would then, for the next question, please elaborate on your time in the Scott County Attorney's Office.
Okay, my time in the Scott County Attorney's Office, as I indicated, I started as a line attorney, meaning I prosecuted primarily misdemeanor, gross misdemeanor, and felony cases ranging from domestic assault to first-degree homicide. I was then promoted to criminal division head, where I supervised the other line attorneys, helped make policies for the county attorney's office, worked with the county attorney to make those policies, and still continue to prosecute cases. I was then promoted to chief deputy, which means I was second in command. So I stood in the shoes of the county attorney. When he wasn't able to do things, I would do that. Still supervise the whole office. Now as the county attorney, I still we have approximately over 50 employees in the county attorney's office. I still continue to prosecute cases, including first-degree homicide, criminal sexual conduct in the first degree, and I remain an active prosecutor in the office.
Mr. Andersen, what is your experience in the Scott County Attorney's Office?
I began working in the county attorney's office as a law clerk or a law school student. And when I started working there, I was helping primarily with the arraignment calendar, so handling first appearances on misdemeanor and petty misdemeanor cases. I was also fortunate enough to be able to work on starting the Scott County Veterans Treatment Court. Along with a victim witness advocate from the office, we wrote a federal grant application that got the funding for the court. We presented to the Scott County Board and got their approval to start the program, as well as some additional funding. And I helped bring together justice partners throughout the county to put together a policy and procedure manual to start a program that helps veterans with mental health and chemical dependency issues address those issues and return to being law-abiding citizens. Once I graduated from law school, I was hired there as a juvenile prosecutor, where I handled cases ranging from minor consumption tickets through felony sex crimes. After serving in the juvenile division, I was assigned to the adult misdemeanor division where I carried a caseload of domestic assault, DWI, theft, such crimes such as that, as well as traffic tickets.
Mr. Andersen, what are the primary duties of the Scott County Attorney?
So the primary duty of any county attorney is twofold. First, it's to protect the rights of the constitutional rights of each and every citizen, and it is to ensure that justice is served. The American Bar Association is the ethical organization that gives the rules to attorneys, and they specifically give guidance to prosecutors that their job is to ensure that justice is served on each and every file. They specifically tell prosecutors their job is not to seek a conviction on each and every file. And so I believe it's a prosecutor's job to ensure that justice is being served on every file. And if justice is being served on every file, then it logically follows that the public safety is going to be served as well. So I believe the primary role of the county attorney is to ensure that the rights of citizens who are charged with crimes within the county are protected, to ensure that the public safety is protected, and to make sure that's done by ensuring justice is done on files and not just seeking convictions.
Mr. Hocevar, what are the primary responsibilities of the Scott County Attorney?
Well, my opponent is partially correct. It is to seek justice and make sure public safety is taken care of, and defendants and victims are given the rights that they deserve. But the county attorney's office does much more than that. We are the law firm for the county. We advise the county commissioners. We have a civil division that reviews all contracts for the county. We have a CHIPS division that is in charge of children in need of protective services. We have a juvenile division that takes care of juveniles. So we do much more than just criminal law. That's the stuff that makes the papers most of the time, but it's important for citizens to realize that that is not all we do. And I have 8 successfully proven years as the Scott County Attorney that have a record of success in that role. It's also important to remember that the treatment court and the vets court were started under my supervision, under my time as the county attorney. So I have over 20 years in the county attorney's office, a record that can be verified as successful.
Mr. Hocevar, what are the greatest strengths of the Scott County Attorney's Office?
The recent strengths of the county attorney's office are my staff, many of whom are sitting here today. I have an absolutely great staff right now, and I could not do the job I do without them. And they do seek justice in every case, and we are not after only convictions in my criminal division. My prosecutors know that, yes, I am tough on crime, and I will not apologize for that, but we are not after convictions. We are after justice. We take care of our victims, and our victims take precedence over a lot of things in our office. I have a very my prosecutors know that the victims must be taken care of. So the strength is, I think, more so my staff than anything, and also after that, to brag about it, my leadership. I have over 20 years in the office with a proven successful track record, and you can go and look at that at any time.
Mr. Andersen, in your view, what are the greatest strengths of the Scott County Attorney's Office?
Well, I hate to sound like a parrot here, but I think that the staff and the people who work in the office is absolutely the right answer to that question. I know specifically during my time as a prosecutor in the office, I made some of the best friends I still have to this day. And there's just really good people. Some of them have moved on to be judges, some have moved on to be defense attorneys, some have moved on to other prosecution jobs. But it's important that all those people were really good people who are doing good work. And I continue to remain friends with people who are prosecutors and staff in the office today. And so I can certainly vouch that they are all very good people doing very good work. I think one of the challenges that the county attorney's office has faced recently is the amount of turnover that's occurred. There's been quite a bit of turnover that's been noticed by myself and other people throughout the county. And unfortunately, a lot of that good staff has left to take those other jobs that I mentioned, leaving for other county attorneys' offices and leaving for the public defender's office in particular. So I certainly think that the strength of the county attorney's office is the people, and I think it's important that those people are retained long-term.
Mr. Hocevar, I see you'd like to rebut that comment.
I would. My opponent has made a big deal out of this supposed turnover in the county attorney's office. And it's just a false narrative. There have been some turnover. He talks about a victim witness person that left. Yeah, she went to the Carlson School of Management to get a master's degree. I'm glad that I was able to help her in that achievement and hope that the job I gave her probably helped her get to that goal. We've had several other people that have left because of familial reasons, being closer to home, taking care of brand new kids that have recently been born. I've had 2 individuals that were selected to be judges, and I take that as a personal compliment and a compliment to the office that they were able to achieve that. Also, it's important to remember that in this COVID area, in the post-COVID area, it's been a time nationwide of individuals, especially in the age category of my opponent, for moving jobs. Nationwide, people have been moving jobs constantly. The staff I have right now is awesome, and they're doing a great job. So I think that narrative of people leaving just for no reason at all is false. And yes, during the course of the year, we did get rid of some dead weight here and there, which is a good thing for the office.
Mr. Anderson, you actually anticipated my next question, and that is, what are the most significant challenges that are facing the Scott County Attorney's Office? So if you'd like to address any other issues.
Thank you. Well, I won't elaborate on the staffing issue any further, but I'd like to bring 2 particular things up here. The first is that I mentioned that I believe one of the most important jobs of a county attorney is to protect the constitutional rights of its citizens. But unfortunately, the county attorney's office recently was found by a district court judge to have particularly violated a defendant's constitutional rights by not disclosing an important piece of evidence in a criminal sexual conduct case. Now, that mistake did not have that case dismissed, which is fortunate, but that individual was still found not guilty of that offense. And the judge did clearly find that that individual's constitutional rights were violated in that matter. Secondly, I would like to bring up that I spoke with a victim who was a victim of a domestic violence crime and was prepared to testify against her abuser at trial, but reached out to me because she was concerned and scared about having to testify because she had never met the prosecutor or the victim witness advocate on her file because the person who had been assigned to it had left, another person had been assigned and left, and she had never met those people before trial. So I think it's important to address those constitutional issues and to make sure those victims are being heard.
Mr. Hocevar, I see you'd like to rebut that.
I would. It's interesting to note that my opponent cherry picks this one case where one particular judge had an issue with one particular file handled by one particular prosecutor in my office. So out of the thousands of cases that I have personally handled, out of the thousands upon thousands of cases my office has handled under my direction, he has found one case where a particular judge found an issue with my office. And I will take that record and defend it every day against my opponent's record. But he has no record. So how can we compare that? He has no record because he's done nothing and really accomplished nothing. And if he remembers, he himself did a criminal sex conduct case with a senior attorney in my office, and he himself had a Brady violation because he didn't prepare his case adequately, where he failed to turn over a sexual assault nurse examination report to the defense attorney.
Mr. Anderson, I see you'd like to rebut.
Yeah, I would just like to briefly mention that I'm not aware of committing a Brady violation. I don't believe that that was ever ruled against me in any way. But there is a public court order that you can certainly look up that explains the Brady violation that I referred to. So I would be certainly welcome to let anybody review my performance reviews from the time I worked under Ron. And I would certainly ask him to, I know that he signed off on those performance reviews, and I got pretty good reviews while I worked underneath him. So I don't believe that I ever committed a Brady violation, and I know for a fact there's no record of that. And I would certainly be willing to release my performance reviews for anybody to view so that they can have a better understanding of what Mr. Hocevar's evaluation of my performance was while I was an employee in the office.
Mr. Hocevar, what are the most significant challenges that are facing the Scott County Attorney's Office?
The most significant challenges relate to obviously crime, drugs, the rising crime. We have fentanyl is destroying our youth. We see overdose deaths are far too prevalent. Our police agencies are going through, I think it's pronounced naloxone, like crazy in order to save people's lives. So the fentanyl coming up illegally through our border and coming up into our youth and into our young people is awful. So the drugs into our system is is a huge issue. It's important to note that if you look at the question and answer that the chamber did with us a few weeks ago that's now published online, my opponent actually made the statement that he was talking about marijuana, then he said, well, actually, all drugs are not a threat to public safety. You can go and look that up, which I almost floored. He actually said that drugs are not a threat to public safety, and they are clearly a threat to public safety, whether it's fentanyl, killing our kids, or people using drugs and driving and committing domestic abuse and so on, and my time is up.
Mr. Anderson.
Thank you. Mr. Hocevar is correct. I did make that statement, and that statement almost directly followed a previous statement that I made in which I was very clear that my policy that I put forward is that I would not continue to prosecute marijuana possession crimes, but I would continue to prosecute distribution and under the influence crimes because I do believe that those are threats to public safety. I do not believe that drug possession or marijuana possession crimes are a threat to public safety because that's an individual choice that causes no harm to anybody else. If you get in a car and drive and hurt somebody, or you're selling drugs to somebody and they contain fentanyl, for example, that is certainly a threat to public safety and that would continue to be prosecuted. But things that are not a threat to public safety, that do not harm anyone but the user themselves, such as drug and marijuana possession crimes, are the ones that I would continue to either not prosecute for marijuana or avoid convictions to the greatest extent possible for other drug crimes.
Mr. Hocevar, what factors do you consider in deciding whether to charge an individual with a criminal offense and what the charge should be?
I'm sorry, could you repeat that?
Yes, what factors do you consider in deciding whether to charge someone with a crime and also what the charge should be?
Sure. First, I'd like to state that the statement that my opponent just made should actually be a bar for him to serve as county attorney. He has stated that he would not follow the law. He has stated that he would not follow the oath he has sworn to take if you are elected as Scott County Attorney. You are sworn to uphold the law whether you agree with them or not. We are not the legislature. We do not make the laws, we enforce the laws. We are part of the executive branch. We do not get to pick and choose what crimes that we have to commit, that we choose to charge somebody with. We have to learn to stay in our lane. There's too many district attorneys and county attorneys across the nation that think that once they're elected, they're all three branches of government. We are not. We do what we're supposed to do, period. As far as what we choose to charge people with, you look at the police reports, got to go very quickly here. You look at the police reports, see if there's actually a probable cause that a crime has been committed and who committed it. Look at the statute, see if we have enough elements of the crime to actually make a charge. And in my office, we specifically have a rule. We don't charge on the probable cause standard. We charge on the proof beyond a reasonable doubt standard, whether we can prove it in court beyond a reasonable doubt or not.
Mr. Anderson, what factors would you consider in deciding whether to charge an individual with a criminal offense and what the charge should be?
Well, I think Mr. Hocevar explained the charging process pretty succinctly, and I don't know that there's much more to add to that. Police officers send in reports, a prosecutor reviews them, determines whether there's a statute in which all the elements have been met, and if they have, then the case is charged. But one thing I would like to improve upon in the county attorney's office is that at the moment, almost every misdemeanor and below offense, with the exception of DWIs and domestic assault offenses, are not reviewed by an attorney prior to the first appearance at an arraignment. So it's a police officer who's making that decision, and the attorneys that review those files almost never get a chance to look at them until right before the arraignment calendar. So by the time an attorney is actually getting eyes on a case like that, a person has already been brought into court for a first appearance and could be facing a misdemeanor charge for a trespass or theft or something along those lines. And so I know I personally had to dismiss cases that either did not meet a beyond a reasonable doubt standard or in which the officer engaged in behavior that would not have been allowed in court. So I do believe that needs to be addressed so that a prosecutor can see those files prior to an arraignment.
And Mr. Anderson, what factors do you consider in seeking a particular sentence?
I think that seeking a sentence is probably the second most important part of what a prosecutor does after the initial charging decision. And after the initial charging decision has been made, a lot more of the individual circumstances need to come into account. So it's important to know why that individual committed that crime, what the circumstances of their life were that surrounded that, and if there's any chance of rehabilitation for that person. The prosecutor themselves is generally not the best person to make that decision, which is why we have to work in conjunction with community corrections who would do the supervision and rehabilitation of that person on probation. But when everybody works together, the prosecutor, probation, and the judges, the vast majority of the time an appropriate outcome can be reached on a sentence. But it's important for the prosecutor to be the gatekeeper there and to ensure that if there is an appropriate sentence that needs to be sought, the prosecutor needs to make sure that that sentence is sought. Alternatively, if there's a conviction that does not need to be sought, even if the judge and/or probation is seeking it, it's the attorney or it's the prosecutor's job to step in and make sure that somebody who does not deserve to be convicted of a crime is not convicted.
Mr. Hocevar, what factors do you consider in seeking a particular sentence?
Well, if the prosecutor doesn't believe that the person should be convicted of a crime, he better start working on the file before he actually gets to sentencing. Sentencing is actually the last stage that you want to do that with. That should be done immediately on the front end. So if the prosecutor is doing their job, it's not going to get to sentencing. For sentencing, you look at the extenuation and mitigation of the crime itself. You look at victims' rights. You check on restitution. You find out what the victim wants to do. It's interesting to note that through the whole chamber question and answer that was previously done and even today, my opponent never talks about victims really. He talked about it when he criticized my office, but victims have rights also, and victims' rights have to be taken care of. So at sentencing, you have to look at the victim's rights, make sure restitution is appropriate, make sure that the victim is getting the restitution, and that victim's wishes and desires, as long as they're within the boundaries of the law, are carried out. We want to take care of our victims out there.
Mr. Hocevar, what are valid purposes of confinement in jail or prison, and do you believe that incarceration is effective?
Do I believe incarceration is effective?
Yes.
Yes. Some people deserve to go to prison, period. Crimes are committed, and they deserve to go to prison. People that commit criminal sexual conduct in the first degree against a 7-year-old girl deserve to go to prison. People who commit first-degree homicide by beheading somebody deserve to go to prison. Not everyone deserves to go to prison, though. As indicated under my administration, treatment court was started, drug court, and a vets court was started. And again, my opponent filled out the grant application for vets court, but again, that was done at my direction under my administration. And I actually had to fight with the judge to get my opponent to be the backup attorney in vets court because they didn't want him there. So it's important to remember that these treatment courts were started under my administration, and I do believe they are effective, and I shouldn't think they should keep operating for certain crimes.
Mr. Andersen, in your view, what are valid purposes of confinement in jail or prison, and do you believe that incarceration is effective?
So I believe that incarceration is effective, but for a very limited group of people. The only people who are truly served by serving a prison sentence or lengthy incarceration are those who are a true threat to public safety. So Mr. Hocevar listed some offenses that I would absolutely agree with should absolutely serve prison time. But unfortunately, the vast majority of the people incarcerated in the United States are not incarcerated for those kinds of offenses. They're incarcerated for nonviolent drug offenses. And I don't believe there's any positive that can come from sending a nonviolent drug user to prison. The treatment programs that are available to them in the prison system are not anywhere near as effective as if they were out of custody. And the chances of them recidivating when they get out do not change because they've not addressed their addiction issues. I would also note that there was recently somebody who was convicted in the county on for a felony drug crime for possessing liquid THC, and the prosecutors are working under the guidelines of the county attorney's office were seeking 45 days of jail and a felony conviction. This gentleman was in had stage 4 cancer and was treating his symptoms with the THC. That is not the kind of person I think needs to be incarcerated or serve any amount of jail time.
Mr. Andersen, what is your view of the Scott County Treatment Court?
I love treatment courts. I've tried to be as upfront and honest with that throughout my entire campaign because I think that the treatment court model is the future of the criminal justice system. I think the whole idea of a treatment court is you find somebody who has a mental health or chemical dependency issue, and but for those issues, they would not be committing crime. So the best thing you can do for that person and for public safety is to get them the help they need to solve that problem and to help them stop committing crimes. And so I believe that that should be spread to everybody. You shouldn't just have to be a veteran or one of the 30 or so people that can get accepted into a drug court program. That should be available to anybody and everybody and anybody who has a qualifying condition and who is willing and able to undergo rehabilitation. And so I would strongly be in favor of starting more courts. I know in particular the Scott County Human Services Department is interested in starting a mental health court, and I would 100% be on board to work with them. I know Mr. Hocevar thinks that a federal grant application is just checking some boxes, but I can guarantee you it was a considerable amount more work than that. And I would be happy to work with Justice Partners in Scott County to do more of that work going forward.
Mr. Hocevar, what is your view of the Scott County Treatment Court?
I'd first like to talk about this marijuana case you brought up. And if it's the case I'm thinking of, my opponent and his supporters have tried to make a big deal out of that, talking about that now he's a felon. Well, he was a felon before. He had prior drug offenses. He was caught with marijuana. He was caught with psilocin, magic mushrooms, and that there's absolutely no indication in the police report that he had cancer. Again, some people deserve to be prosecuted. I love treatment court. It's great. It works. It's been proven to work. Vets court's working. Being a veteran myself, I was in full support of that and still am. So it does work, but not for everybody. Not everybody. My opponent would have everybody come through the criminal justice system in some kind of a specialty court. Number one, it takes money. The commissioners already talk about whether it's financially feasible to keep both of these courts going. You need judges, you need prosecutors, you need community corrections agents, you need psychologists, you need human services people. Money out there is not endless. We have a budget to keep. He's never done a budget. I've got 8 years as county attorney of doing a budget. So it takes more than this pie in the sky idea. Well, let's have more specialty courts. It's not just going to happen.
Mr. Anderson, you'd like to make a rebuttal?
Yes, thank you. I'll address the treatment courts in a moment here, but I'd like to be clear that I have done a budget. When I was in the Marine Corps, I was in charge of several $1 million worth of rolling stock, which I had to create a budget for and maintain the budget while I was platoon leader in Iwakuni, Japan. I was motor transport operator in charge of the heavy section, and so I did create a budget for several $1 million worth of rolling stock. I've not done one for a county attorney's office, but I'm pretty confident that I can handle that. As far as treatment courts go, essentially every piece of research and evidence that exists on treatment courts shows that not only are they financially feasible, but they save taxpayers money. You're not incarcerating people as often. They're not being prosecuted repeatedly, sucking up resources. And once those people are out of the criminal justice system, you're not prosecuting repeat drug offenders who are not a threat to society. So if you want to do any basic internet research, you'll learn that the treatment courts are not only financially feasible, but they save taxpayers money.
Mr. Hocevar, what factors determine whether treatment court is appropriate for a particular person?
What their issues are. You have to look at the issues that they're having. First off, the crime committed. Obviously, I would never approve of somebody that committed a homicide go to treatment court. And let's just be clear, I'm not against specialty courts. I'm all for our treatment court. I'm all for our veterans court. But right now, we don't need any more than that. You look at the crime that's been committed, whether it qualifies for treatment court or not. You look at whether it's going to be a good program for that person. They're voluntary. You can't force somebody into a specialty court. So you can't have someone that's charged with a crime and say, okay, you're going to vets court, you're going to treatment court. It has to be voluntary, or else it's not going to do them any good. It's just like going to treatment, it has to be voluntary. They have to accept it. So you look at the crime charge, we always check with the victim of a crime. We check the victims to make sure that they're okay with this individual going into a specialty court. So it's a matter of whether you look at the crime committed, whether it's a good fit for them, and whether they can do it. The treatment court is much more, it's tougher on them than actually them pleading guilty and just going to regular probation. So it takes a special person and special circumstances for them to be able to get into it and complete it.
Mr. Anderson, in your view, what factors determine whether treatment court is appropriate for a particular person?
So when a treatment court program is created, they create what's called a policy and procedure manual, and it lists all the requirements that somebody will need to meet in order to get into the program. Those manuals include the offenses that the person can be charged with in order to come into the program. In the drug court, for example, they don't take nonviolent crimes, but in the veterans court, they do. And the reason for that is that when you are trained to respond to something with violence, they don't train that out of you when you get out of the military. So those two specialty courts need to have a different set of crimes that can go into each of them. Now, when someone's interested in joining, they meet with a professional, either a psychologist or some sort of other treatment professional who does an assessment on them. And that's after they usually get an initial assessment from somebody from community corrections. And based on those assessments, you get a risk level and a needs level. The risk level determines their level of supervision, and the needs determines whether they need to go to some sort of treatment. After those recommendations are made, then the determination can be made whether that person is a good fit for the program. As Mr. Hocevar mentioned, it's then the prosecutor's job to work out a plea agreement so that that person can enter a guilty plea and come into the program.
Mr. Andersen, what is the role of community feedback regarding justice system policy, and should public opinion affect law enforcement decisions in the county attorney's office?
I certainly think it's important for the county attorney to represent all the citizens of the county, so the county's feedback on policy is certainly important. In particular, there was a marijuana possession case recently where they had to dismiss 12 straight jurors because each of those jurors said they did not believe marijuana possession should be a crime and said that they could not be an impartial juror in that case. That case went all the way to the conclusion, and I spoke with the public defender and some others who worked on that case, and each of them believed that was a case of what's called jury nullification, meaning the jury believed that the individual was in fact guilty of possessing that marijuana, but did not believe that that should be illegal, so they chose to find that individual not guilty, and he was acquitted of that offense.
Mr. Hocevar, what is the role of community feedback regarding justice system policy, and should public opinion affect law enforcement decisions in the county attorney's office?
First off, we don't know what the jury thought in that case. The feedback I got from that file is that it was a situation where marijuana was found in a jacket, which was not on the person at the time. So the jury believed that it was somebody else's jacket, basically, or we couldn't prove beyond reasonable doubt that it was that person's, not necessarily nullification. So I don't think the public defender or my opponent has actually spoken to the jury about that case. As far as public opinion dictating as far as what police do, what my office do, obviously we have to learn, we have to listen to public opinion, we have to take into consideration what the people have to say. We don't want the police going out there and going roughshod over people that don't need to be gone roughshod over, or my office actually doing things that the public doesn't necessarily want to have done. But the bottom line is we have to follow the law, as I've stated previously. We have a role to play in following the law. The police have a role to play in enforcing the law. So that's what we have to do. But we certainly do listen to the public all the time. I'm out in the public all the time giving speeches and talks about various things. And I do listen to the public on a daily basis.
Mr. Hocevar, do you believe it's a waste of public money to prosecute marijuana possession offenses, and why or why not?
And why?
Yes.
No, I don't believe it's a waste of public money. And again, the county attorney is not the legislature. If the legislature changes the law, my office will adapt and follow the law. But as of right now, as we stand here today, possession of marijuana is illegal. And my opponent again talks about on his previous question and answer session about a waste of resources that this takes in the office. Since January 1st of this year, out of over 2,800 felony files, there's 14 marijuana cases. 14. That's a drop in the bucket. My office is not wasting a lot of time or money on marijuana cases. It's just not happening. So again, we take an oath to enforce and execute the laws of the state of Minnesota, period. If the legislature changes it, whether that be next year, 2 years, 5 or 10 years from now, my office will adapt accordingly. We don't even know. Everyone speculates that's going to happen, but we don't know.
Mr. Andersen, do you believe it is a waste of public money to prosecute marijuana possession offenses, and why or why not?
So this is a question about resources, so I'm going to try to stay on subject there. But yeah, I absolutely think it's a waste of public taxpayer money to prosecute marijuana offenses. As I mentioned earlier, I don't believe that those who simply possess marijuana are any threat to public safety whatsoever. And the county attorney's office, as Mr. Hocevar noted, has a significantly high caseload that they need to work with. So even if there is only 12 up to this point felony cases, which do not include any of the petty misdemeanor or below cases, or the petty misdemeanor cases, any of those cases that are being worked on or any resources that are being used by a prosecutor to work on those are being wasted and should be used on prosecuting violent crime. Additionally, as we've seen the legalization spread throughout the country, nearly or every state that has passed a marijuana legalization bill has included an expungement component with that, meaning that prior marijuana convictions had to be administratively removed from people's criminal records. And so not only is it a waste on the front end to use resources to prosecute people who aren't threats to public safety, it's going to be a waste of resources to have to go back and undo all those convictions down the road.
Mr. Hocevar.
Thank you. Again, not to beat a dead horse here, but we don't currently live in a state where marijuana is legal, period. That's our job as a district attorney, county attorney, is to enforce the law. That's what we do. And you talked about petty misdemeanor cases. Those don't even get to my office. Those are done they're payable, so it's not a crime. They're petties, and they're done by a hearing officer. So very rarely will we even see a petty or a misdemeanor marijuana possession case, because the petties are non-crimes, so no one's having a criminal conviction, and the other ones are done by a hearing officer. So we're not wasting resources in my office. We're not wasting attorney time in my office on these. And the 14 or 12 or 14 felony files we do have for marijuana, my opponent wouldn't know because he hasn't done it. It takes very little time to prepare and prosecute.
Mr. Andersen, do you believe that the cash bail system needs to be reformed? And if so, how?
Yeah, I absolutely think cash bail needs to be reformed. I think that it is not an effective way to determine who is and who is not a threat to public safety. You can have a wealthy individual who drives drunk and kills somebody and can post bail and sit at home while they await trial. Meanwhile, a poor individual can commit a property offense, have a minimal amount of bail imposed, and have to sit in custody until their case is resolved. That's not an effective way to determine which of those people is a threat to public safety and which isn't. I will say that I don't know that there is a good solution at this point to replace bail because it's a relatively new area that's being studied. But I would certainly remain open to any and all possibilities of replacing cash bail. In particular, pretrial supervision is useful, and I'm a big fan of the use of unsecured bond, which would impose a bail amount on an individual, but they would not have to actually post that bail to get out of jail. If they were to violate a release condition or to miss a court date, at that point then a warrant would issue for that person. They'd be brought into custody and they'd be required to pay that cash bail amount. So although I don't believe that there is a firm solution right now, I would continue to remain open to that and to replace it as soon as there's a viable solution.
Mr. Hocevar, in your opinion, does the cash bail system need to be reformed? And if so, how?
No. As my opponent just admitted, there is no viable alternative right now. I think it works just fine. I can guarantee you, under my administration, we will never turn into a jurisdiction like you see in other points in the country, San Francisco, LA, Southern District of New York, Chicago, what have you, even some counties in Minnesota, where you have this merry-go-round of criminals entering the jail, exiting the jail, entering the jail, exiting the jail, and committing more crimes. That will not happen under my administration. I think bail is a very good form of trying to keep people from committing more crimes for public safety. You can't have, it's a very important part of keeping domestic violence victims safe. I mean, you put someone in jail that they just got done, and I don't want to sound sexist, but most of our domestic violence victims are females. You don't want to have that person posting or getting out of jail right away with no conditions and going back home. We have to have a bail system that keeps our public safe, and that merry-go-round jail system will not happen under my administration.
Mr. Hocevar, what are the most important issues for the civil division of the county attorney's office?
It's lots. Condemnations, mental health with the commitments. Commitments are out of control. We have so many people that are going through commitments now. We've got 3 homicide defendants that have forensic psychological examinations that have deemed them incompetent to stand trial. So our civil division is working with the psychologists, working with the professionals to figure out whether they should be committed or not. So we're trying to get them committed as mentally ill and dangerous, because you can't have somebody who just beheaded somebody put back onto the street. And going back to bail, right now somebody could go bail him out right now because there's cash bail on him. He could be bailed out walking the streets tonight. So the biggest issue is mental health and civil commitments. They're way up. The legislature did designate funds in the last session to help get people competent again. You can read about that in the Southwest papers pretty soon. But my time is up.
Mr. Andersen, what are the most important issues for the civil division in the county attorney's office?
So civil has really been a big learning experience for me recently. As I mentioned, after I left the county attorney's office, I started working at Hennepin County Adult Representation Services. And that's an organization in which I carry a housing caseload, but my colleagues represent parents of kids in child protection. They represent those facing civil commitments, and they represent those facing contempt proceedings. Those are all things in which the county attorney is involved in. And so I've had an opportunity to learn all those areas of law a lot more than I did just as a criminal prosecutor. And as you heard Mr. Hocevar say earlier, his experiences as a criminal prosecutor his entire career. So I feel confident now that I've had the opportunity to work in a civil division that I have both criminal and civil experience in which the county attorney works. And I think the most important work that they do is in the CHIPS field. That's the child protection field in which children are taken away from their parents generally due to either a chemical dependency issue, a mental health issue, or some sort of violence that's going on in the home. And the goal of child protection in Minnesota is to reunify the family. And so I think that's the most important work that the county attorney's office does, is to help those families reunify.
Our time is running out. Anyone whose questions have not been answered should ask the candidates this evening after the debate or contact their campaign offices. You can find more information about the candidates at the Chamber's website, shakopee.org. Each candidate will now have 1 minute for their closing statement, beginning with Alan Andersen.
Thank you. Throughout this campaign, there's been a lot made of age, experience, and partisanship. These are tactics used simply to distract voters from comparing the policy of two candidates. I am young. I turned 33 on Halloween, but I'm not inexperienced, and I'm not a partisan candidate. The county attorney position is nonpartisan because the justice system serves to protect everyone's constitutional rights and to protect public safety regardless of party affiliation. I ask that you ignore the attempts to distract you and compare the policies I've proposed, which you can read in detail on my website, to the policies proposed by my opponent. The policies I advocate for have been shown to be effective through research and data, and I've shown an ability to implement those policies in Scott County. My opponent's policies are unchanged from the last decade of his leadership. We may not all agree how the justice system is broken or how to fix it, but I think we can all agree it's in need of change. Having the experience leading our system into its current state isn't a positive, it's a negative. I believe it's time for a change in the Scott County Attorney's Office, and I'd be honored to lead that change. Thank you.
Mr. Hocevar.
Well, thank you. He talks about change, but he never talks about really why, other than that he's young. That's not really a valid reason for a change. He also talked about the fact that I don't have any experience with the civil people. As chief deputy for 12 years and county attorney for 8 years, I oversee and oversaw everything, including the civil division, and dealt with the contracts, the condemnations, the commitments. So that's just not true. The bottom line is this, really. You can look at my experience, and you can look at my opponent's experience. I've done the job for over 20 years, 8 as county attorney. He hasn't. I've tried every conceivable criminal case there is. He hasn't. I've dealt with civil commitments on a level basis. He hasn't. And here's the thing. You might agree with some of the things he said, disagree with some of the things I've said, disagree with some of the things I've said, agree with some of the things he said, vice versa, whatever. But this is an important position. It's the county attorney, the lead law enforcement agent in the county. And you want to trust that with somebody who's never done it, has absolutely zero experience, or someone with a proven track record of success. I ask for your vote in November. Thank you.
As we close this part of our discussion, please remember that the views expressed in tonight's debate are those of the candidates, not those of the Chamber and Visitors Bureau. The Chamber sponsors this event as a service to the community and has gone to extraordinary lengths to ensure the objectivity of this forum. The Chamber does not endorse any candidate. Instead, we seek to provide the information you need to make an informed choice when you vote. Thank you to the audience this evening and to River Valley Church for hosting our event. On behalf of the Shakopee Chamber and Visitors Bureau, thank you to both of the candidates. We appreciate your time and your service to our community. Election Day is Tuesday, November 8th. Please remember to vote.